the national prosecutor, and that expected of his chosen legal representative in the inquiry proceedings. It is contended that the NPA's case is not properly advanced and that the procedure, open quote, followed in the inquiry is preventing a proper and fair ventilation of the facts, close quote, and is adversarial. It is further contended that the evidence leaders, open quote, are not sufficiently au fait with the intricacies of all the facts related to the matter and have not managed to digest the sheer volume of documents and are unable to properly present the true facts, close quote. These remarks are deeply concerning to the panel as they were to Advocate Chauke's legal representatives. It must be said from the outset that these remarks are not only condescending, but lose sight of the fact that not only the evidence leaders, but also Advocate Chauke's legal representatives and the panel also had to consider the same sheer volume of documents within a short space of time. Everybody else has done everything they had to do to the best of their ability. The contentions, denigrating as they appear, cannot be used as a basis to draw unfounded conclusions by the deponent to the NPA's founding affidavit. As it happens, it is understandable why Advocate Hale SC is more familiar with the contents of the sheer volume referred to. In his own words, he has been involved in these NPA matters for a period spanning almost 6 years, dealing with different aspects of this matter when everybody else has been involved in this matter for only a few months. The criticism leveled at the evidence leaders is therefore unwarranted and misplaced. The NPA seeks to assert its alleged right to have its own independent status and to be represented by counsel of its choice in the inquiry proceedings. Additionally, the NPA asks that the procedural rules of the inquiry be amended with a view to lead evidence and cross-examine witnesses through its chosen counsel, Advocate Hale SC and Advocate Ngcukaitobi. It is contended that this is to ensure that its interests are best served. The NPA seeks the following relief. 1, permitting the National Prosecuting Authority to participate in the proceedings of the inquiry as a separate and independent party from the evidence leading team. 2, in furtherance of Prayer 1 above, directing that the NPA, through its chosen legal representatives, may 2.1, adduce evidence that the evidence leaders have elected not to adduce or have not adduced. 2.2, question witnesses, including witnesses called by Advocate Chauke and Advocate Chauke himself, on any issue not raised by the evidence leaders. 2.3, question witnesses, raise objections to questions put in the cross-examination by any witness. 2.4, generally, to make submissions and address the panel on substantive issues that may arise during the proceedings on equal footing with the evidence leaders and counsel for Advocate Chauke. 3, amending the rules to reflect the directives contained in paragraphs 1 and 2 above, close quote. The second respondent, Advocate Masinyane Andrew Chauke, opposes the application. The opposition is based on several grounds. Broadly, that there is neither factual nor legal basis for granting the relief sought. Advocate Chauke asks that the application should therefore be dismissed. The evidence leading team does not oppose the application and will abide the ruling of the panel. A brief background is necessary. The complaint, which culminated in the establishment of the inquiry, was initiated by the NPA through its head, the erstwhile National Director of Public Prosecution (NDPP), Advocate Shamila Batoyi. As gleaned from her affidavit, Advocate Batoyi was a prosecutor since 1985 and served as the Director of Public Prosecutions (DPP) of KwaZulu-Natal, KZN, for a period of about 10 years before taking appointment as a senior legal advisor at the International Criminal Court in The Hague in November 2009. She returned to South Africa and took up the position as the NDPP from 1 February 2019. Advocate Batoyi states she discovered various allegations that, according to her, had wrecked the NPA and its credibility when she took office as NDPP. Some of these allegations involved certain senior advocates, including Advocate Ngcukaitobi, the former Deputy National Director of Public Prosecution, DNDPP. The complaints against Advocate Jiba involved Major General Boysons, the former head of the Directorate of Priority Crime Investigation, DPCI, later known as the Hawks, KZN. The complaint against Advocate Chauke relates to a great extent to the issues that were raised against Advocate Jiba in the Mokoro inquiry. It is not necessary for the purpose of this ruling to give details regarding those issues. Suffice it to mention that pursuant to the complaint against Advocate Chauke by Advocate Batoyi, the President, acting under Section 12.6, read with Section 14.3 of the National Prosecuting Authority Act 32 of 1998, the NPA Act, suspended the former provisionally pending the inquiry into his fitness to hold office as DPP Gauteng South. Of significance are the provisions of Section 12.6A, capital A, in terms of which the period from the time the President suspended Advocate Chauke to the time he decides whether or not to remove him from office may not exceed 12 months. Given the fact that Advocate Chauke was suspended on 20 July 2025, the inquiry must therefore be concluded by 19 July 2026. It is for this reason that the work of the inquiry should not be delayed any further. Having suspended Advocate Chauke, the President established the inquiry on 19 September 2025 in terms of Section 12.6A of the NPA Act. It needs to be stressed that other than Advocate Chauke, neither the NPA nor the erstwhile NDPP, Advocate Batoyi, is the subject matter of this inquiry. Contemporaneously with the establishment of the inquiry, the President appointed a panel consisting of the chairperson to chair the inquiry and 2 panel members, ourselves, to assist the chairperson, me, as a chairperson, and also determine the inquiry's procedural rules. The task of the panel is to inquire into, report on, and make findings and/or recommendations on allegations leveled against Advocate Chauke. The allegations are set out in the Terms of Reference, TOR, published in Government Gazette number 53444, dated 30 September 2025. The chairperson is empowered, in terms of the TOR, to determine the rules of the procedure of the inquiry. Initially, the inquiry was to be completed within 4 months. The period within which the inquiry must be finalized has since been extended because, as at the end of the 4th month, only one witness' testimony had been partially tendered. Rule 2.1 of the inquiry rules makes it plain that the inquiry shall be conducted in an inquisitorial manner. In other words, the proceedings are not adversarial. The inquisitorial process in an official inquiry in which a panel takes a proactive role is to ascertain the truth, while adversarial processes, especially in criminal and civil proceedings, use competitive processes between the parties to determine the true facts. In both criminal and civil, the proceedings are victory-driven, but the former process is not. Despite the fact that the NPA acknowledges the provisions of the rules regarding the nature of the inquiry, the deponent, Advocate Karen van Rensburg, states that the proceedings of the inquiry are in large measure adversarial in nature. On this basis alone, she states that the NPA is concerned that its complaint may not be adequately presented and therefore seeks that it be represented by its own legal representatives. The posture of the NPA regarding the nature of the proceedings, that it is in large measure adversarial, is unfounded, speculative, and disingenuous. It falls to be rejected outrightly. Principally, the purpose of the inquiry is to unearth the facts and seek the truth. This application has been in the offing from at least 5 December 2025. This March is confirmed by the NPA deponent. The NPA, through Advocate Halley, had agreed with the guidance of the panel that the correct approach would be to bring a substantive application in which the relief to be sought will be clearly set out. It was agreed with the Council for the NPA that the application will be filed as soon as possible. The application was, however, only launched on or about 12 February 2026. The explanation advanced by the NPA through Advocate van Rensburg is that this application was prepared a while back when Advocate Batoyi was testifying. Advocate van Rensburg states that it was decided that the application should not be filed at that stage, as doing so will be perceived as an attempt on the part of the NPA to influence Advocate Batoyi's testimony. She further says that she was made to understand that the panel was advised that this application would be brought only after Advocate Batoyi had completed her testimony. To the best of the panel's recollection of events, no such advice was given. The deponent does not even explain who, according to her, advised the panel. Manifestly, these statements are based on hearsay, as there are no confirmatory affidavits to support them. The statement is thus baseless and must be rejected. The issues for determination, as distilled from the papers, revolve around the NPA's right to seek full participation in the proceedings. More specifically, it claims for participatory entitlement. Its claim for participatory entitlement, I beg your pardon, is founded on the NPA's alleged right, inter alia, to A, adduce evidence that the evidence leaders have elected not to adduce or not have adduced. B, cross-examine witnesses and advocate Chauke on any issue not raised by the evidence leaders. And C, make submissions. A further question for determination is whether, supposedly if the relief sought as regards the participatory involvement is granted, the rules of the inquiry should be amended. Properly understood, the real basis for the MPA's case, as was submitted in a volte-face during argument when its counsel, Advocate Hali SC, was confronted with questioning from the panel, is merely anticipatory. As will be shown, this submission is supported by the assertion of Advocate van Rensburg in the founding papers. Determination of issues. Is the NPA entitled, as of right, to adduce evidence? Before addressing this question, it is important to deal briefly with the roles of evidence leaders and that of the NPA's legal representatives. Tellingly from their title, the responsibility of the evidence leaders, who are led by Advocate Motlamunyane SC, is none other than leading evidence with a view to assist the panel in the performance of its task in terms of the TOR. In many instances during the proceedings, when evidence leaders drifted away or lost focus from their responsibility, the chairperson reminded them to be non-partisan and that they should assume a neutral and independent role in the inquiry proceedings. Juxtaposing the responsibility of the evidence leaders with the standing and or role of the NPA, it is beyond question that the NPA was not appointed and or intended to lead evidence at an inquisitorial process such as the inquiry. The NPA is the complainant. Its legal representatives were not and could not therefore be appointed to lead evidence in a matter in which it is the complainant, which may be the case in an internal disciplinary hearing. Had that been the case, we consider the work of the panel would be hamstrung. Unmistakably, more specifically given the issues raised in the TOR, the NPA is the repository of most of the documentary evidence relevant for the purpose of the inquiry. Its supportive and or assistive role was correctly accepted by Advocate Hali, not only during argument in this application, but also in the course of the inquiry proceedings on 21 November 2025, when the following pertinent, albeit lengthy, exchange between the chairperson and him took place. Advocate Hali, SC. There was a lack of pagination and a lack of an index yesterday. We will give an undertaking that we will attend to it. So I agree with your understanding of how matters get placed onto the record. Chairperson, thank you, Advocate Hali, and the NPA team. We hope that that will be the case. Advocate Hali, Madam Commissioner, If I could raise another matter, I just want to make it clear, lest it be misunderstood. The evidence leader, and I'm not part of the evidence leaders team, I understand that Madam Chairperson is using that as a shorthand, but I do think that it is important to place it on record, lest there be a misconception. The evidence leader decides how he is going to lead the case, and we will provide him with assistance as you have directed in the past. And we are more than willing to do so. But it is his choice as to which witness he calls, how he conducts the case. It is not our choice, and we are not his. My junior is not his junior. She is my junior. For the time being, my junior is assisting him to find pages, find documents, and so forth. But we are part of the NPA team. We are not part of the evidence leading team. Chairperson, yes, you will recall that we discussed these matters at length because all of you belong to the NPA. You may be occupying different spaces. I'm saying that in the sense that Advocate Mutlamuyane cannot operate without the NPA. Advocate Halley, I accept. Chairperson, otherwise we will not be here. Advocate Halley, I accept that. Chairperson, and for expediency, as I mentioned earlier, it will be proper that you work as a team. Advocate Halley, indeed. Chairperson, and I do appreciate that you are not necessarily an evidence leader, but you work as a team to assist the inquiry. So I think that that spirit that we spoke about in chambers, towards that common goal, I beg your pardon. So I think that in that spirit that we spoke about in chambers is to work towards the common goal. We are here to serve the interests of the country, to present evidence, to assist the inquiry. But if you go back and forth and say that this is not my space, and we may as well go home because we are not going to be enabled to do our work as an inquiry. I still plead with all of you that we work together to ensure that we have all the material that we need. And despite the fact that you have your junior, I still expect that these two juniors will work together as a team and confer with one another. Advocate Mutlamuyane, we will, Madam Chair. Chairperson, in that spirit of collegiality. Advocate Mutlamuyane, indeed, close quote. This passage highlights the common understanding between the NPA team and the evidence leading team of the necessity of a collaborative effort. To recap on the question raised above, the NPA's claim is that it is entitled to adduce evidence with the evidence leading team, elected not to adduce or have not adduced. Contextually, the claim is founded on the following passage. Paragraph 55 of the founding papers. In short, the NPA is of the view that its case is not being properly advanced in these proceedings. Paragraph 56. Whilst the NPA understand the independent and neutral role played by the evidence leaders, it is concerned that in discharging this role, there may be and are disagreements between the NPA and the evidence leaders on which witnesses to call and what evidence to present. It is concerning to the NPA that whilst the evidence leaders must be independent and neutral, they are required to represent the NPA, being one of the parties in what has at times become an adversarial dispute. The evidence leaders may also decide not to pose certain questions to witnesses called. In any of these events, the NPA submits that it ought, in the interest of procedural fairness, to be allowed through its chosen legal representatives to present its own case. Paragraph 57. In any of these circumstances, the NPA is in a worse position than an ordinary third party, close quote. When questioned on the speculative statements apparent from the quoted passages above, Advocate Halley submitted that the application is anticipatory. A claim for or an entitlement to procedural fairness must be based on information that is correct and objectively verifiable and not merely on preventive action based on conjecture. The panel has been referred to numerous authorities regarding the entitlement to adduce evidence. These authorities, upon the cursory reading thereof, reflect tried principles of law, but bear no relevance to the issues of fact raised in this matter. In any event, the proposed midstream intervention by the NPA in the inquiry's proceedings will not only cause further delays, but also impact unfairly on matters pertaining to the alleged misconduct by Advocate Chauke. Inquiries on matters concerning alleged misconduct, procedurally or substantively, should be dealt with expeditiously. When asked further about why the evidence leaders will not lead the witnesses and whether there is any evidence showing that the NPA provided them with evidence which they have elected not to adduce, Advocate Halley responded that the purpose of today's application is simply that we should be allowed to lead evidence if they choose not to lead evidence. That is the purpose. Council accepted the basis of the application was based on what may happen in the future if the evidence leaders decide not to tender the information the NPA presents to them. The NPA has been represented by 2 advocates since the inception of the inquiry. At no stage has Advocate Halley approached the panel and suggested that the evidence leaders have declined to present information to the panel. Moreover, the application does not even disclose what information, if any, the NPA has in its possession that it seeks to present to the evidence leaders. As correctly submitted by Advocate Ngcukaitobi SC on behalf of Advocate Chauke, there is simply no factual or legal basis for granting the relief sought, i.e., entitling the NPA to lead evidence separately and independently. The claimed entitlement is thus misconceived. The relief sought in paragraph 2.1 of the notice of motion must therefore be refused. Does the NPA, through its chosen legal team, have a right to cross-examine witnesses, including Advocate Chauke, and raise objections to questions put in cross-examination? It is contended that if the NPA is not afforded this right, its interest will not be best served. Relying on the principle of equality of arms, the NPA compares itself with Advocate Chauke. It is stated that Advocate Chauke is represented by attorneys and counsel who are given leave to cross-examine witnesses called by the evidence leaders. They give an example of Advocate Chauke's team having been given the right to cross-examine Advocate Muiponi Noko. We hasten to mention that nothing prevented the NPA from presenting its questions to the evidence leading team to pose the questions to the witnesses. As regards the question of interest raised above, the NPA seems to be concerned about its interest only. It is unmindful of the deeper public interest in an inquiry such as this one. The inquiry is not an inter partes kind of a litigation. Instead, it does not only serve to unravel the truth, but seeks also to promote the principle of accountability. Additionally, although the inquiry is not a commission under the Commissions Act 8 of 1947, its work in searching for the truth will also restore public confidence by revealing the truth on matters of great public interest that the inquiry is investigating. The principles espoused in the decisions of the Constitutional Court in Premier Western Cape and the Secretary of the Judicial Commission of Inquiry into allegations of state capture, as referred to in footnotes 2 and 3 above, apply with equal force here. The further authorities referred to by the NPA relating to the procedure in an inquiry under Section 12(6) of the NPA Act include the Jiba versus President of the Republic of South Africa and others, Jiba, and the Democratic Alliance versus the President of the Republic of South Africa and others, DA. They also bear no relevance. In Jiba, Advocate Jiba was the then acting National Director of Public Prosecutions who had been afforded an opportunity to respond to the recommendations made by the President and to make representations on why the recommendation should not be implemented. Affording her, Advocate Jiba, those protections, as the court remarked, was also to ensure that the independence of the NPA was protected. In the DA matter, the court dealt with the rationality principle, in terms of which a decision will be irrational when relevant information is ignored. In this matter, the NPA has not pointed to any evidence that the panel has ignored. The said authorities do not assist the NPA. Therefore, the relief sought in paragraph 2.3 of the notice of motion to cross-examine and raise objections to questions put in cross-examination should be refused. What is the source of the claimed right? The NPA contended that its claimed rights are sourced, among others, from sections 34 and 35(3)(I) of the Constitution, i.e., the right to fair public hearing and the right guaranteed to every accused person to challenge evidence, respectively. Reliance is also placed on Section 1661 of the Criminal Procedure Act 51 of 1977, the CPA, that confers upon an accused person the right to cross-examine any prosecution witness. Furthermore, the NPA relies on Uniform Rules of Court, Rules 38.2 and 39.15, the civil trial rules. Additionally, the NPA relies on the rules of natural justice as well as the principle of legitimate expectation. We were referred to a plethora of authorities in this regard. In our view, the authorities do not assist the claims of the NPA in the circumstances of this matter. The proceedings of the inquiry are neither civil nor criminal in nature, as Mr. Chauke is neither a defendant nor an accused person. Therefore, the provisions referred to above are of no relevance whatsoever. As regards the claimed legitimate expectation, the MPA has not shown any such right that stands to be adversely affected by the anticipated recommendation of the panel in the inquiry. The NPA has been represented in this proceeding. The fact that it is not separately and independently represented by the legal representatives of its own choice is not in and of itself prejudicial to it. Its legal representatives are aware of the circumstances that led to Advocate Noko's request that she be called to testify by either the panel or Advocate Chauke's team. They are also aware that Advocate Noko was called to testify by the panel, which means that she was the panel's witness. Any suggestion that Advocate Chauke's team wasn't any suggestion that Advocate Chauke's team was not entitled to cross-examine her is baseless. The comparison and reliance on the principles of equality of arms in the circumstances of this case is unfounded and falls to be rejected. In contrast, as regards prejudice, there can be no doubt that Advocate Chauke stands to be prejudiced if the NPA is granted the relief it seeks in the notice of motion. Firstly, as correctly submitted on behalf of Advocate Chauke, he will face duplicative rounds of cross-examination by the evidence leaders and the NPA. Secondly, the proposed structural changes will cause delays in finalizing the work of the inquiry, which has been repeatedly mentioned, must be finalized by July 2026. As it is, there is still a lot of grounds to cover before this date. Thirdly, the proposed relief will result in different procedural rules applicable to certain witnesses but not to others. Lastly, the inquiry proceedings will indeed degenerate into an adversarial process. In its replying affidavit, the NPA suggests that it does not want to act as a prosecutor. However, its claimed rights is founded on Section 35 of the Constitution and Section 166(1) of the CPA. This is telling. It follows that the entitlement the MPA asserts are substantively prosecutorial. Clearly, the MPA's spirited argument disregards the nature of the inquiry proceedings, and its attitude seeks to favor a particular cause. The MPA's claim, if successful, will be unhelpful to the inquiry. These views are supported by the NPA's further claim to have the rules of the inquiry amended. In our view, the attitude and approach of the NPA is not only dilatory but also constitute an abuse of the inquiry process. Such an attitude and approach cannot, in the circumstances, be countenanced. In closing, we emphasize that the MPA's interests are adequately represented in the inquiry. The evidence leaders are independent and should be neutral. Their independence or neutrality, as Advocate Ngcukaitobi correctly pointed out, does not preclude them, the evidence leaders, from presenting all relevant information to the inquiry, whether favorable to Advocate Chauke or not. This view is consistent with an inquisitorial nature of the inquiry proceedings. the application lacks merit and should be dismissed. Order. Accordingly, the application is dismissed.
As you please, Madam Chair.
We hand the ruling down. Advocate Ngcukaitobi and Advocate Musamunyane, through you, Madam, and through my two sisters in front of me. We are going to pause. We had anticipated that we'll finish just before 11 o'clock, but we have a full hour for adjournment so that you can prepare yourselves. Please convey to Advocate Musamunyane and Advocate Mtsweni that we finished earlier than we had anticipated. But we reckon that this will afford them an opportunity to finalize the cross-examination. And I suppose the 1 hour period will also enable our spokesperson, together with our transcribers, to communicate with the ambassadorial office in Greece to make sure that we don't encounter problems that we encountered yesterday, to the extent reasonably possible. Council, as we mentioned in chambers, we will use this time between 10 o'clock and 11 o'clock for tea as well, meaning that we will not adjourn until our lunch break, unless we need 5 or 10 minutes to stretch our legs. But we will not adjourn again for tea between say 11 and lunchtime. Thank you. We adjourn. Good morning, everyone. Good morning, Advocate Chauke again. Good morning, Mr. Danikas.
Good morning, Madam Chair.
We are just about to begin, and I have to remind you that you are still under oath.
Yes, indeed,
Thank you.
Madam Chair.
Thank you. Advocate Mutlamunyane. Proceed.
Thank you, Madam Chair, and your two sisters. Good morning, Mr. Danikas.
Good morning, Chair.
I am the evidence leader, and I'm going to ask you questions. I hope you are fine today. It was a bit
I'm okay,
chilly.
thank you,
It was a
sir.
bit chilly in South Africa this morning. How's Greece?
Greece is a bit cold. Just came back from the hospital where my mother is, so I'm not having the greatest of day.
Yeah, let's hope she recovers, she recuperates. But let's go on.
Appreciate it.
Yeah, let's go on with the work. Mr. Danikas, you testified yesterday when asked about your attempts to assist South Africa, that during 2012 you had a 2 days meeting with General Mabula at the South African Embassy. Is that correct?
That's correct, Chair.
During the meeting, you told them everything and produced the evidence you had in your possession. Is that correct?
I don't recall if I told them everything. It's a long time ago, but I did produce certain evidence and I gave them information.
And in the same meeting with General Mabula, he wanted you to come with them or follow them to South Africa in order to sign a statement. Is that correct?
That is correct, sir.
He even undertook that you will not leave the airport. You will just touch the ground, sign the statement, and fly back to Greece, which offer you declined. Is that correct?
If you allow me to make a correction, Chair, it's my understanding that I will land in South Africa's soil. I will stay at the airport hotel, sign the statement, and then fly with the first flight back to Greece.
That is okay. I accept that. You said to him you were happy to help, but you are not prepared to come to South Africa, not so?
Chair, yes, I had concerns serious about my safety in South Africa, and I wanted to secure my safety and the safety of my family first.
Was General Mabula accompanied by someone else, or was he alone?
There was a team of members. I honestly cannot recall the names, but there was a team.
By the way, it was in April, if you can clarify that, April 2012.
Chair, I don't remember the month, I'll be honest with you. It will be in my notes somewhere, but I cannot confirm the month.
And during the meeting, Mabula and his team typed notes as you narrated the story. Is that correct?
From my recollection, yes, that's correct. If I may ask, that there was a team and they were taking notes. While they were making me questions, I was doing a presentation, giving them evidence on a laptop, showing the evidence which I brought on a memory stick, and they were all making notes.
Now, you say those notes constitute the document that is contained in file 2 of the cross-examination bundle which you were shown by your legal representatives, not so? Is that the document at page 454? It's page 454 of the cross-examination bundle, Madam Chair.
May I have the PDF page number so I can see it on my screen? So it's enlarged, please. Is it page 54?
454, it's flighted on the screen, Mr. Danikas. Do you see it?
I can only see 4 lines of it. I, Iris Danikas, up to my life end. Okay, now I can see it.
Yeah. If Mr. Mutlukwani can assist us, go to the top of the statement. Or can you read there on the left hand corner on top there? It's written draft statement by Iris Danikas.
That's correct, sir.
And your contact details appear there. Do you see them?
Indeed.
And then it says to whom it may concern.
Yes, sir.
Now, you gave the notes with a view that a formal statement will be prepared and you will sign once the mutual legal assistance is in place. Not so?
Chair, I would like to add some context to that. The mutual legal agreement was not something that I recall mentioned during the very first visit of General Mabula. In fact, I don't think General Mabula at the time knew anything about MLA agreement and how the system works. It is my understanding that there was an impression also that I will be able to sign my statement, this draft statement, at the embassy because General Mabula considered it to be South African soil. So in 2012, at the embassy, I don't recall them speaking about MLA procedure. General Mabula was not, it's my opinion, he wasn't familiarized with the process. And neither was I. That came after they left. They went back to South Africa. And then I think the NPA got directly involved with me, and then they described the MLA procedure.
I see. Fair enough. You and your family at that stage had asked for state witness protection from General Mabula. Is that correct?
That's correct. It was during the negotiations at the embassy, an ongoing negotiation.
The notes that you gave to General Mabula were given by yourself with a view to prepare your statement. Is that correct? To prepare a formal statement?
Not necessarily, Chair. I recall on the first meeting in the presence of my attorney that we did not want to disclose. I was reluctant to give a formal statement. So I was assured that the draft notes will remain confidential draft notes up until arrangements were made for my safety, and then I will be giving a formal statement. So it was subject to conditions. I was assured that the draft note, it's what we call a whistleblower, a source, providing information. That was my understanding in 2012.
Will I therefore be correct if I say when General Mabula left Greece in 2012, it had been clear to you and General Mabula that the document that you are looking at page 454, file 2 of the cross-examination bundle, was not a statement, but notes?
That was my understanding.
which notes will then be used to develop a statement or prepare a statement.
Well, the basis of my information, with my logic, the basis of my information and the information I liaise from 2012 onwards, in my logic, it will develop to a statement once we agree on terms and conditions of my safety and the witness protection program.
At the time, therefore, in April 2012, you had not agreed to be a witness because there was no statement.
Chair, again, I had agreed to become a witness for the prosecution, providing they give me protection. So the obstacle was waiting for the protection to be secured so I can be a witness. In the meantime, I was providing information for the case as a whistleblower. But I wanted to be a witness, and that's why I facilitated numerous of communication with authorities in South Africa in terms of going to the embassy all the time.
If you go to page 457 of that statement, those notes, at the bottom there you will see there's a handwritten note there that reads, "The draft was prepared and handed over to me at SA Embassy on 2012-04-18 at 1650 by Mr. Aritanikas of Athens, Greece." Confirm that?
Sir, I confirm that I can identify notes, but I wasn't in a position, I don't understand the word prepared. I couldn't have typed that. My skills are not such, especially in 2012, to type that, but somebody else was typing it, and obviously I will narrate the context and discuss it with the people, with the team.
After General Mabula had left Greece, you started communicating with Advocate Maema. Is that correct?
I recall, yes. Someone in the line, Advocate Maema, got in the picture.
I take it you also made it clear to Maema that you will not sign the statement until the MLS was in place.
The MLA, correct.
MLA, I'm sorry. The MLA was in place, and you and your family have been provided with state protection.
Actually, I'd like to provide some context to that. Because I'm not a legal expert, I was not aware of the term MLA until it was introduced by Advocate Maema. My position was that, and my attorney's position, that I would not go back to testify to South Africa because of fear of my life. I was willing to sign a statement and testify, providing I have security measures in place. So somewhere across the line between our first initial meeting at the embassy and then the next period of time, we received an email with a draft and MLA paperwork on it to assure us that preparations were made by the National Prosecution Authority in South Africa to prepare the MLA agreement. And this is how I was explained by the attorneys what the MLA stands for.
Okay, let me take you to page 458 of the same bundle, if Mr. Motlokwane can assist us in that regard. You see the document on page 458?
Indeed, I see the beginning of it on my screen because I have a small screen
Yeah,
on
maybe.
my laptop.
Do you want to see the whole of it? You can identify the document?
I can identify the document.
After speaking to Maema, to Advocate Maema, this document on page 458 was prepared with a view to prepare the MLA, Mutual Legal Assistance.
You can refer to it as the statement of Aris Danicus, as it is written there.
Yeah,
so that anyone who reads this transcript will know the document that you are talking about.
Thank you, Madam Chair. The statement is written on top, statement of Aris Danicus. And it starts on page 458 and ends on page 472. May I recap my previous question to you, Mr. Danicus?
Yes, sorry, Chair, I'm confused. Am I looking at my statement now, or am I looking at the statement on the screen?
It's a statement on page 458, and I'm going to ask you a question about that statement. It says, statement of Aris Danicus.
Okay, sure.
After you spoke to Advocate Maema, this document on this page, your statement, the statement of Aris Danicus, was prepared with a view to prepare the MLA, Mutual Legal Assistance document. Not so?
I assume so, but I won't have, it will probably come towards my turn is for me to review and go through it, ask for legal assistance here in Greece into maybe explain to me context, translate some parts to Greek and understand the context of that and maybe do alterations, because I cannot accept the statement as is made from South Africa. I wouldn't have signed it, put it this way. I would first go through it, process it, and perhaps make changes. But it was something I recognized that came as an email, and I believe it came to prove to us that they were taking steps towards my statement to be prepared via mutual legal agreement process.
And this document was prepared by Advocate Maema, is that correct?
Which document?
I cannot recall
the
that.
statement,
I can only. Sorry.
I'm sorry, Mr. Danicus. The statement of Aris Danicus.
I don't recall who prepared it. There will be an email correspondence, so it will have an accompanying letter or cover letter, but it will have the details. But I cannot answer of who prepared that statement for me, not of back my memory.
Can you go at to the bottom of the page? There are initials.
How can I do that?
There are initials there. Do you see them?
Oh, okay. I've seen that now.
The one is just an initial. The other has letters there. It says GSM.
I see that now.
Okay. Now, in 2016, you had a meeting with Advocate Maema and Advocate McAdam, which you refer to as Advocate Dawood McAdam in Greece. Is that correct?
That is correct, sir.
During the meeting, may I proceed, Madam Chair? Perhaps I'm too fast. May I proceed?
No, you proceed.
Thank you, Madam Chair. During the meeting, Advocate Maema and Advocate Dawood McAdam made all sorts of promises to you. that is about the MLA and state protection for you and your family. Not correct?
Chair, the MLA was not a promise. We were waiting for it to arrive. My understanding was, and that was according to General Mambula, that the very first MLA process that they initiated back in 2012, it was their understanding that it had been sabotaged and delayed for no reason that I know of. But the promises were yes for protection. That's correct. They made promises.
At that meeting, you still maintained that you'll only sign the statement and testify once your conditions have been fulfilled. Not so?
That's correct. That was my initial desire, if I put it that way.
It was in October 2016 when Advocate Maema and Advocate Dawood Mekadam met you in Greece.
Chair, I have to see my statement about the month. I just don't remember months anymore. But it was in 2016.
Now, when Advocate Maema and Advocate Mekadam left Greece, they still had no statement from you.
Chair, on that meeting, I had two attorneys present, an advocate from the UK and a Greek attorney present. We discussed a lot of aspects about my securing my witness protection as well as the MLA agreement, the pending MLA agreement. At that stage, I was enthusiastic and collaborating with them and wanted to comply fully and sign my mutual legal agreement. I was happy to testify because by then they had told me themselves, we're not bringing you back to South Africa. It's very risky. You will be testifying from a Commonwealth country, and they mentioned a command center, as we call it, a secure place in the UK. So I was very happy of collaborating and signing my pending statement. The scope of that meeting was, and that's my understanding, it was, and I think I have a sound recording to that effect. The scope of the meeting, Chair, was to take out the misunderstandings, take out any bad blood, as we call it, if I may say that, and build a new trust, meeting Advocate Maema, explaining the situation, the delays, the misunderstandings, that letter that was issued previously that confused me, and to explain me the process in the presence of my advocates. So it was explained to me that, Ari, in order to provide you with witness protection, we have to have a written statement from you. That's the procedure of the law in South Africa. So MC Adams suggested that he will enter me on a 15-day preliminary witness protection. That will give him enough time to fly back to South Africa, speak to the minister, if I recall correctly, and get the mutual legal agreement in order, send it back to Greece to get signed so I can have my witness protection. So it was my understanding at that point that if I did not sign my mutual legal agreement statement that it was pending, I could not get security and enter the witness protection. However, at that stage, we had a presentation in front of the NPA team. I made the presentation, and it's actually a screen also, a big screen, and we did the presentation. I presented my evidence one by one, videos, transcripts, photographs, case numbers, background, and then I proceed of handing over officially my evidence to the National Prosecution Authority. They were sealed and processed, as I know, been an ex-crime scene investigator doing so, sold them in the plastic bag, signed, and collected officially. I don't know if that helps you, Chair.
Yes, it does. But after that exercise, there was still no agreement between yourselves that you will testify. Not so?
No, there was an agreement. That's what I just said. Because they make me understand that I'm entering a preliminary 15 days witness protection. Basically, we gave them time. I was happy to sign a mutual legal agreement based on what was said to us and to my two advocates.
You then later signed...
That's why I gave the evidence. And I did it in the formal way. It was part of the process.
You signed the Greek version of your statement at a later stage, not so?
Well, I wouldn't call it a Greek version. I would call it a Greek statement. The mutual legal agreement arrived with, I recall, in Greek. It was a Greek, according to the authorities here, it was a Greek request in Greek for part of it, and we follow the procedure as the international collaboration stipulates. So I follow the rules as I was guided.
You signed that Greek statement despite the fact that there was no protection.
I have, Chair, a phone conversation.
I beg your pardon. Before you answer, Counsel, please repeat your question.
You signed the statement despite receiving state protection.
If I may understand the question, was the protection that she sought in relation to him making a statement or in relation to him coming to South Africa as he was requested?
Is this question to me?
Yes, maybe you should answer that, Mr. Danika's yes. You are
Maybe
absolutely,
I think
he can rescue me.
you are correct. I'm asking whether, on the basis of the question asked by Counsel, whether the protection you sought was in relation to you signing a statement or in relation to...
Sorry, there was a delay on the Wi-Fi. I can hear you again.
Counsel is saying to you, you signed the Greek statement despite the fact that you had not received the protection. Is that the question? Advocate Motlamonyane? I see you counsels are having a conference over there whilst we are busy trying to address the question that you are asking. I think we have to respect the process.
Our apologies, Madam Chair.
Please repeat your question to the witness.
You signed the statement despite the witness protection program being in place.
Not being
in place.
Can I answer that?
Maybe you can answer because I understood the statement differently, but do answer for yourself.
I can answer, and with the same context, I can also respond to your question, Madam Chair, if I may. So, I was waiting and waiting for that statement to arrive. And there was a delayed process, frustration, communication, and eventually the MLA statement surfaced magically. The way I signed it, I referred to it yesterday, the circumstances of my signing that statement. Now then, prior to signing, or when the MLA agreement arrived and I was informed that it was pending and they were looking for me to sign that statement, I phoned Advocate Maema. That conversation has been recorded and I think is handed to the evidence leaders. On that conversation, I said to Advocate Maema, and now I'm going to summarize, I said, look, because I want justice and because I would like to see those people getting prosecuted for the crimes, even if I don't have yet security and I'm still not in the witness protection, I will go and sign the statement. And I went and I signed the statement, although I did not have protection. I took this calculative risk eventually that particular time. And I have this sound recording of the conversation with Advocate Maema.
After, let me rephrase. The Greek version statement was later translated into the English version and sent to you. Is that correct?
Chair, I'm sorry, maybe I have a problem with the word version, or maybe my translation from English to Greek misguides me. I will consider my Greek statement the original and only statement I ever made and signed. And then there was a translated version of my Greek statement, which I had nothing to do with it. It was done by the appropriate channels in South Africa, and it was emailed to me as a courtesy to have a look at it by Advocate Maema over an email. And I think it was a heated email also, which I can provide context to it. Does that cover you?
Now, after you discovered that there were small errors, it could have been typographical errors, you then corrected them and sent the Greek statement to Advocate Maema, the translated statement to Advocate Maema.
No, that's not what happened, sorry, Chair. What happened is, it was a casual email. It was at the end, I think before 2019, around 2018. By the time I also had enough, so I was disappointed with what's happening. I was tired, worn out, and there was a heated email correspondence, which I think, and I recall from my memory again, I complained about what was going on, the delays, and then I said, in the end of my email, I said, by the way, out of courtesy, because I remember I used the word courtesy, so it was like a context of a conversation, and by the way, I received a translation. Look, I picked up 1 or 2, 3 little errors, and I see this being wrong, translated by your translator, which I presume wasn't a native-speaking translator. To that context, it was the conversation. It wasn't like a formal received translation, which I had to redo or meticulously scrutinize and correct and send back. Nothing to that extent.
Now, after it was sent back, after the translated version was sent back to Advocate Maema, you never signed the corrected translated English version.
Chair, again, I did not send back a translated version. I just made some notes of certain words. It was like an email saying, by the way, I don't know how to explain it. I used words, and then I said, this is wrong, and it means that, this is wrong, this means. So it was a whole translation sent back to them. And that was the end of it. The Advocate Maema said, okay, thank you so much, we'll attend to it. And that was the end of it.
Go to the same file on page 494 thereof, the cross-examination bundle, file 2.
Sorry, I have to see this on the screen.
Yeah, I'll ask that it be flighted to you on page 494, Madam Chair.
Thank you, that's better.
Perhaps it will be prudent if we start at 480, where this statement begins. It says...
Chair, that is a translation. Apologies, Chair. Sorry, I thought you asked me a question.
My apologies, Mr. Danikas. It says official translation, witness sworn testimony report. That's where your statement starts. And on page 494, if you can go there, at the bottom there appears a signature. Do you see that, Mr. Danikas?
Chair, if I may comment and give context.
Excuse me, under the caption signature witness of witness.
I see that. Can I provide context to that?
Is that your signature?
That is a copy of my signature, but...
Just a minute, just hang on. Sorry.
Sorry, apologies.
Does that signature appear the last page of the translated version?
494, the last page, Madam Chair. Before the last one where it's written the investigator, apparently it's a commissioner of oaths, I should think. But at the bottom, 494, there appears a signature under the caption signature of witness.
Yes, thank you.
Thank you, Madam Chair. Can you identify that signature?
Yes, I can, Chair.
Whose signature is it?
Chair, this appears to be a copy of my signature, but it's not only the signature. Look next to it. There are two Greek words to it. Υπογραφή μάρτυρα, which means signature of witness. So what this is, and if you take my Greek statement, that exact context is being taken over. It's like the signature. It says signature of witness, which translation of the sentence υπογραφή μάρτυρα. So it's my understanding, and I'll provide context to that, that this is the last part of my original statement, my Greek statement, which has the part of what is being translated. And my signature has been translated, because you can see again, and I emphasize on the right of my signature, υπογραφή μάρτυρα. That is not typed and the font is different. So one has to do the exercise of taking my Greek statement, go to the bottom of it, and see if this is the exact same sentence used by the whoever conducted the translation. Furthermore, I had the same question, which I took it to the Mutual Legal Agreement Office here in Greece. And the judge, I think Panagiotis Karakostatis was his name, told me this is a standard procedure that we do internationally when it gets translated, because we need to, it's a bureaucratic thing. We translate, or the office translate everything. Now, a signature cannot be translated. But, so what they do is, you see the dots under my signature, and again the two words, υπογραφή μάρτυρα, that is a translation of what it says on top, signature of witness. So to me, I was explaining, was a formality of the translation process.
So you never signed this statement, this English translated statement. You never signed it.
I was never asked, never signed it, never asked to. And again, I was told by the Mutual Legal Agreement Office that it doesn't make sense to sign it because it defeats all the purpose of the Mutual Legal Agreement process.
Mr. Danikas, can you then confirm to this panel that to date, there is no agreement between you and the NPA that you will testify because your conditions have not been met? Is that correct?
No, that's not correct, sir. As I mentioned earlier on, I took a calculative risk to sign and provide my mutual legal agreement, which means I agreed to collaborate with the mutual legal agreement, with the South African authorities, because my understanding was that once I signed my mutual legal agreement, then I would get, before I testify, after I sign, my understanding was I would get witness protection. However, my next correspondence with Advocate Maema was that the case was dropped, after I have also found in the media that it was dropped. And I started talking to see what's going on. And he told me himself, the case is dropped. Sorry for this inconvenience. So there was not much time to continue.
Madam Chair,
May I just come in here? Before you, I see you have already proceeded to another topic. And I want to take you back to the topic of the signature on the English version. I don't know whether you were present when evidence was laid regarding the signature on this English statement. It has been referred to somewhere as a superimposed signature and so forth. And if you were present, you would have heard when Advocate Maema indicated to this panel that the signature that appears on the English version is the signature that was superimposed by the person that interpreted or translated the Greek statement. So when you ask about the signatures, I just want to bring that to your attention, and with a view to saying, is he the correct person to deal with about the signature? More so that he has said, I never sent back a corrected English statement. What I did was to write notes to indicate as to where there are faults. And he makes it even abundantly clear by saying, I had nothing to do with the English statement. All what I know is that I signed a statement that was written in Greek, and I own that statement as my original statement.
Thank you, Madam Ramahaha. I will not quarrel with that.
Yeah, no, it doesn't help for us to,
Yes.
we just want to understand. If we share the understanding, it will be clear that we are. But when you say, I will not quarrel with that, that leaves it hanging as an uncertainty. Well, that's my understanding. But if you have a different understanding, you can then proceed.
What I mean is, I will accept your explanation, Madam Chair. I take it.
Yes, it is on record, and I think the record will speak for itself. In the event that later you'd like to quarrel with it, or the evidence leaders would like to, as they prepare their submissions. Thank you, Mr. Motlamanyane.
Thank you, Madam Ramahaha. Madam Chair, I will leave this aspect of the statement.
Before you leave this aspect, you took us to page 458. Yes, and referred to the initials there, but you never took it further. I've been holding that page. I've been keeping my finger on that page, waiting for the question.
I was afraid to take it any further. Just wanted to let it be, just be seen. I was afraid
Counsel, you can't be afraid.
to take it any further. Because it's,
Please, you have to feel free to present the evidence through cross-examination. And when you place it on record that you are afraid to do what you're supposed to do, I get consent. Why would you be afraid to present your cross-examination the way you consider it appropriate?
I was afraid perhaps I would be testifying from the bar if I take it further than I have done, because it says GSM. And I put it to him that it was Maema, Advocate Maema rather, who prepared this statement. And these are his initials. I did not want
You
it to
can ask the witness, do you know whose signature is appended, Mr. Danikas,
Yes, Madam Chair.
in relation to the point that was raised by counsel in relation to page 458, SM6. He referred to the signature at the bottom of that page. That is the first page of the statement he referred to. You see those, there are two signatures there. The one is GSM.
I see that, Madam Chair.
Do you know who is GSM, or can you, are you able to identify whose signature it is?
No, I don't. I've never paid attention to that, Madam Chair.
I beg your pardon?
I have never paid attention to those details.
You have no idea. You may take the point further
No.
if you wish.
Thank you, Madam Chair. Mr. Danikas, GSM, as far as we know in this inquiry, are initials of Advocate Maema. His full names are Gladstone Sello Maema. Can't deny that.
Just told you
He
that
says so.
He says he doesn't know who
I don't know.
it is, Mr. Mahlamanyane, counsel.
I'll leave it at
He
that.
can't take it any further. He doesn't know whose signature it is.
I'll leave it at that, Madam Chair.
Before you leave the point, counsel, you had also asked the witness the question. There was no agreement with the NPA that you will testify. Do you wish to pursue that question, or are you abandoning it?
I thought he had answered it. Let me then ask it again, Madam Chair.
He answered it, but I want to pursue it. Let us assume there was no agreement. What then? What should we make of that? Does it really matter for our purpose?
It doesn't matter, really.
Doesn't matter.
No, it doesn't matter.
Yes. You may proceed.
Thank you, Madam Chair. Mr. Danikas, you have your statement before this panel in front of you, not so?
Yes, I have, Chair. Are you referring to the latest statement I did now to the panel or my previous one to the NPA?
Go to paragraph 40 of your statement, which is contained on page 4-12.
I'm a bit confused, Chair. Are we referring to the recent statement I've made for your panel, for the Commission inquiry?
I'm referring to the witness statement that you have been referred to yesterday for a considerable period of time. You also read from the statement yesterday, your own statement.
Okay, let me understand that. Is that the one that starts with, I was frequently permitted to take photographs?
No, I'm talking about witness statement in which your names, on the first page, your name appears as Aristidis Danikas.
Can somebody point me to that statement? Because I don't have access to that statement. It has to be on the screen of the laptop so I can see it.
May I just assist here? You referred him to page 412.
Yeah, 4-12.
And then he said, is it the one that starts with, I was frequently permitted? Maybe you were not paying attention then.
I missed.
Because that is the very page that you are looking for. Okay, no, then that's fine.
Yeah, I missed. Yeah, Mr. Danigas, my apologies, I missed it. It is the same statement, paragraph 40, that starts with, I was frequently permitted. Now,
Thank you, Chair.
down the page, you indicated that the members of the Katomana unit routinely took these pictures to share among themselves and to praise themselves of their successes. You see that?
That's correct, sir. That's correct, sir.
You are not saying it was General Boysen who routinely took those pictures, not so?
When I refer to members of the Katomana unit, I refer to Johan Bosch as being part of the Katomana unit. That's the way I have seen it because of the way we were interacting with each other. So I will include General Boysen. In fact, I have a photo of General Boysen posing, which I personally took, he asked me to take, together with other members, with the dead suspect, African suspect.
Okay, so you are generalizing in this paragraph, not so?
I'm referring to the Katomana unit, including Johan Boysen. Let me be specific.
You met Major General Boysen, as he then was, as far back as 1996 or 1997, according to your evidence. Is that correct?
Correct.
And then you became well acquainted with his family. Is that correct?
Indeed. And him.
You actually became friends with the family, not so?
Indeed.
To a point that you even traveled to Europe with him and his family after he had requested you to accompany him, not so?
Yes, indeed. He even stayed in my house for 6 months when his own house was built.
And that was in 2001.
Yes, if the recollection of my thoughts are correct, it was around that time.
If your recollection can help you, do you remember the month?
I can't remember the month, sorry, but I mean, I have video footage of the whole holiday, so that's very easily to find out.
At the time, you knew what kind of man he was. Because in early 1998 or 1999, you were invited to their offices where you witnessed the torturing of a suspect. Not so?
That's correct, sir. But now, you asked me a question which is quite general, what kind of man he was. It takes time to process information, filter information, and start realizing what's going on. It's not, we are human beings, so we're not robots or machines. So, we act different to information received and situations. So it took me time to understand how bad it was.
Mr. Danikas, after realizing that the Katomana police officers were what you call, quote, untouchables, they were calling Africans with K names, calling them apes, among others. Why did you not retreat and leave this unit?
Chair, I tried to. In fact, I sent a letter, a fax to Pat Brown, as I said yesterday to my statement, and Johan Boysen hijacked that letter, which probably Pat Brown gave it to him, and he came personally and he told me, look, Ari, and that's what Boysen was doing. He was working on my phobia, which I had, about my personal safety. He told me, Ari, if you leave my unit, you cannot be protected. I will have to take your firearm away, and you'll go to another unit which you'll do only desk work due to IT, so you won't be protected. That was interpreted as a message And this is why in 2008, early 2008, I went to the newspapers and I said, I'm thinking now of resigning the force.
Were you forced to stay in the force?
In fact, I was, Chair, and I can prove that. I sent a letter to the South African police services saying I'm resigning from the force. And the official response was, we did not accept your resignation. I have the letter. If you don't have it as evidence, I can provide it and email it to you.
You say you can provide that letter in an email.
Absolutely. I have the original email signed by Director Kennedy, the head of the reserve force, who responded to me as a reservist, which I have the constitutional right to resign, and it starts with, we do not accept the resignation. Then they go about telling me what a good super duper police work I've done, exceptional work, because I had been doing exceptional work on my own investigations, and I had numerous awards. I call them awards. Anyway, I don't know how to call it in English, even from Bosch himself. And they told me, we don't accept your resignation.
Counsel, I am really trying to restrain myself from cautioning you. I'm not sure whether you have forgotten the terms of reference of this inquiry, what we seek to attain. These questions may well be very relevant at the criminal trial, but I'm not sure the line of questioning. What do you seek to establish, if I may ask?
I'm seeking, Madam Chair, to establish inconsistencies and his general behavior. And we want to demonstrate that he actually benefited from being a member of Katomana.
That may well be so, but for what relevance is that for our purpose as an inquiry, bearing in mind the terms of reference and the issues raised therein?
Well, he came before this tribunal and gave us what he gave us in his statement, and his testimony has to be tested to some degree as to whether it is correct or not. But I take your point, Madam Chair. I take your point about the terms of reference.
Now, let me take you back to your statement. You are correct, Counsel, that finally this panel will look at the evidence in its entirety and make a determination of what is correct and what is not correct, but only for the purpose of the task we have to execute in relation to the terms of reference, nothing less, nothing more.
I take your point, Madam Chair.
May I just come in here, please? Just to say about the issue of benefiting and so forth. I agree fully with my sister, but I think the record also speaks for itself. If I understood his testimony well, he admits to having benefited. He has highlighted issues like getting a firearm again after. He has highlighted issues like being protected, his own business being protected, and so forth. He just gave us a list of, well, it's not a closed list, but he demonstrated and volunteered the information that he benefited from being a reservist at the Katomana.
Thank you, Madam Ramagaga and Madam Chair. I take your points. Let me leap over to other points, if you allow me. May I proceed, Madam Chair?
You may proceed, sir.
Let me take you to Berea CAS, which you discuss on page Berea CAS 288. You discuss on page 4-25. This is the only case which is relevant to this inquiry. Relevant in this sense, Mr. Danikas, it falls within the indictment period. Do you have a comment there?
Chair, I'm not a legal expert. It's only what I read in the papers, so I don't think I have a comment to that.
Did your attorneys not tell you that there is what we refer to as the indictment period here being the period between the years 2008 to 2011?
Madam Chair,
That has been mentioned.
I just want to make my learned friend know that we don't accept their interpretation about the relevant events in relation to poker. Advocate Mayema made it clear that his interpretation of poker at the time was that contextual evidence was admissible. I just want to make that clear. There's no point in canvassing legal matter with this witness, but we did have Advocate Mayema where this question was pertinently raised. Thank you, ma'am.
Let me maybe put it differently, Advocate Ngcukaitobi. Advocate Motlamanyane, look at page 4-32, paragraph 105. This paragraph was dealt with yesterday by Advocate Ngcukaitobi. And if you read the contents of that paragraph, it refers you to a period, 1990 to 1995. You see that?
Paragraph 105, Madam Chair.
Yes. It refers to the report titled Breaking with the Past. You remember that?
Yes, I do.
That report is an annexure. It's a very long document that relates to events between 1990 and 1995. It is annexure AD 24. You remember that?
I remember the document, Madam Chair.
And in paragraph 105. My recollection, when counsel drew Advocate Danika's attention to 105, he made mentions of the similar patterns. You can even see it there in that paragraph. It's highlighted there. And he says, I further noted that similar patterns of conduct had been documented. Now, in relation to the events, you remember the case of Nkanyana that was in 1998, if my recollection is correct, Nkanyana. You can page through that paragraph. Can't remember where it is.
It's on 4A259, Madam Chair. 4A259, the bundle.
In the statement, where in the statement did Mr. Danikas talk about the Nkanyana matter?
Madam Chair, we could short circuit this. The that paragraph you've read, paragraph 105.
Yes.
At the end says specific reference to General Boyson and Captain Vili Olivier, who were both employed at Katumano, appear at pages 181 to 186 of the report. And then Ngwanyana is in those pages.
Yes. Thank you, Councillor. And Ngwanyana, if you remember, is one of those matters that do not form part of the indictment. You remember?
Yes, Madam Chair.
But its relevance if my recollection is correct, mention was made of, Mr. Danikas will correct me if I'm wrong, that it was showing the pattern of the conduct of the Katumena unit. I have to go to my notes. But if my recollection is correct, that's why he kept those cases within the statement to show the pattern, as he does in paragraph 105, referring to old matters, 1990 to 1995, and it refers to that that report of the breaking with the past.
Chair, if I may provide some help.
Yes, you may actually even correct me if I'm wrong. Thank you, Mr. Danikas.
Thank you, Madam Chair. So we're looking at 4A259. That's what the document is. And it's case 8, death of Vusi Kanyana, Isipigo DR 792, dated 12th of March 1992. That is, there's a finding from the Goldstone report, and it's the late Frank Dutton, the investigator on the case. He has identified 2 members of the murder and robbery unit, which is Captain Johan Boyson. We are talking about the same General Boyson now, and we are talking about, just give me a second, Willie Fear, who was Willie Fear, or Wally as we call them. He was the commanding officer of the Ghetto Manor. I'm not sure how it works, but those 2, from the apartheid times, and it's my interpretation, forgive me if I'm overstepping, they were killing suspects, and this case shows a pattern where to me it's to the investigator officer, it's an unjustified killing of an African suspect during apartheid times, 1992, shot him at the back, unarmed, fleeing, so no risk involved. And it's further comments that they mess up with the investigation, they are appointing themselves to investigate themselves. That's how I interpreted this. This is why all those years I included on my website. I even gave this case to the NPA. I've given it to General Mabula. And I was frustrated because nobody was paying attention. And I'm Greek, I'm in Greece, and I gotta pay attention to things like that to alert the South African authorities. It was a frustrating time for me.
Yes, what you referred to, the earlier cases that you referred to, in which you say Major General Boyson was involved, do show similar fact evidence. Am I correct?
Yeah, correct, Madam Chair. I call them copy-paste evidence.
What do you call them?
Copy-paste.
Copy-paste evidence.
Thank you, Madam Chair. Mr. Danikas, go to page 422-22 of your statement.
Chair, again, because my statement is not numbered, it only has paragraphs. It will be helpful if you just give me the paragraph number so I can trace it.
I'm going there, paragraph 71.
Thank you so much, Chair. I'm there, Chair.
Yeah, let's start with paragraph 68, whilst you're on that page. Paragraph 68 starts
I'm there, Chair.
overleaf and then remain on page 422. Now,
Again, I don't have the pages. Apologies.
now you say in paragraph 68, just on top of the page, that Mr. Georgiadis, Arthur Georgiadis, who was not a SAPS member, was also invited to attend to the scene. Do you see that?
Sorry, you asked me a question, Chair?
Yeah, I'm saying you said Mr. Arthur Georgiadis, who was not a SAPS member, was invited to accompany you and General Boysen to the scene.
He was invited by General Boysen to see how his members are killing Africans. That was the exact words that he said in front of another 5 people at my house.
He said, Arthur, do you want to see how we kill the Mavros? Using a Greek term, Mavros, meaning blacks or dark-skinned persons.
That is correct, sir.
Mr. Georgiadis then confirmed what happened in a statement, not so. In an email, rather. Not so.
Chair, he confirmed. Sorry, I thought you were finished. Apologies.
You said,
Why are you reading, Council?
I'm putting a proposition to him that Mr. Georgiadis confirmed in an email. And I'll go to the email, Madam Chair.
Maybe just finish the question so that I'm sure it has dates and et cetera, et cetera.
The email is an annexure, AD 15, on page 4A-27.
I am there, sir.
Arthur Georgiadis writes to you and says, in paragraph 2 of that email, he says, I'm writing you this email to confirm the events that occurred on 8 April 2007. You see that?
Yes, sir.
AD 27, is that what you referred to, Council?
AD 15, Madam Chair.
AD 15.
Yes. Page 4A-27.
Chair, the email you referred to first is AD 12. I wrote to Arthur and he responded on AD 15.
For 827, Madam Ramachaka.
The witness says he wrote to Arthur, AD 12. Maybe you wish to start there.
AD 12.
Are you answering the question by Council referring you to Arthur's email, and then you said you wrote to him at AD 12, referring to your email. You see that at 4A26. Did you want to develop that answer in relation to the email of Mr. Georgiadis.
The same thing.
Madam Chair, the two documents are the same. They are from
8012
ATA.
and 8015.
Yes,
Oh, yes.
Oh, yeah.
Are the same thing.
they are from
Yeah,
ATA
yeah.
Georgiadis to
Oh,
Ari.
yes.
To
They
the
are
witness.
the same. It's a repetition there.
Okay.
Yes. Yes, thank you, Council. It's a repetition. Council referred you to AD 15 and you referred to AD 12. Let's stick to AD 15, the numbering. Proceed, Council.
Thank you, Madam Chair. You are acquainted with the contents of this email. We don't have to read the whole of it, Mr. Danikas.
Yes, I am, Chair.
Arthur Georgiadis does not mention what you allege General Johan Boysen has told him about Mavros. He doesn't mention it in this email.
It's not a statement under oath, Council. It's just an email.
Yes.
It is not a statement under oath, correct?
Correct, Madam Chair.
And the witness has made a statement under oath in relation to the point, the paragraph that you referred us to of his statement.
Yes, this witness has made his statement under oath, Madam Chair.
You proceed, Council.
Thank you. Mr. Georgiadis does not state in this email anything about Mavros. And remember, he was reporting to you. He was confirming what had taken place on that day. That's what he says. Do you follow?
I follow, Chair. I just don't understand the point of the question, but please, carry on. Ask me a question.
The question is, what you say General Johan Boysen has stated about Mavros to Georgiadis, Mr. Georgiadis, the latter does not confirm what you said in paragraph 68 of your statement. Do you have a comment there?
Must I reply to that? Respond?
Yes, please answer, Mr. Danikas.
So, Chair, that is the very first email I contacted Arthur Georgiadis after he left South Africa and he immigrated to Malta. So it was an initial email to engage the conversation because John Clark made a video which is online, and if you see that video, you will hear a more detailed live elaboration of what is discussed. So I don't think, and I can't speak for Arthur, but Arthur is a witness and he's willing to testify under oath if he's reached out by the evidence leaders. So I think he gave me a summary, and the details will have been explained on a sworn testimony.
He continues to say in this document, in this email, that he discovered later that when the paramedics were allowed to attend to the shot suspects, they had already died. Nowhere in this document, in this email, is he saying General Johan Boysen refused the injured person medical attention.
It says the paramedics were not allowed into the scene until the crime scene were properly secured. I discovered later that when the paramedics were allowed to attend to the shot suspects, they had already died. Upon his arrival, Johan took control of the crime scene, giving instructions to members of the unit that were involved in the shooting. So again, we have to ask Arthur to provide context of what he means with that.
Let's leave it.
Madam Chair, I'm terribly sorry, but the question was misleading. But the witness, I think, has clarified it, but it needs to be recorded that the question was misleading. It incorrectly recorded the email.
Advocate Mutlamonyani, can we go back to the email?
I'm on the email, Madam Chair. May I respond?
Yes.
I do not understand what is misleading in this email that my learned colleague is referring to. What is misleading? Maybe he should clarify what he says. I am pronouncing a misleading proposition.
My learned friend says to the witness that nowhere does the email say that General Johan Boysen prevented the paramedics from entering the scene. But if you look at the third paragraph, it is specific. Paramedics were not allowed onto the scene until the crime scene was properly secure. I discovered later that when the paramedics were allowed to attend to the shot suspects, they had already died. And who was in control of the scene? The following paragraphs. Upon his arrival of the crime scene, giving instructions to members of the unit that were involved in the shootings. At one stage, they went to your apartment where you showed us the video you shot at the crime scene. Johan commented to you that you'd better get rid of it or you will get yourself into trouble. So it's misleading first because it's not reading the full email. It's also misleading because it is misrepresenting the contents of the email.
I do not agree, but I'll leave it at that. I do not agree with my learned colleague that it's misleading, but I'll leave it at that and jump on to the next aspect.
But did you read the entire email?
Yes, I read the entire email, Madam Chair. In the entire email, there's nowhere where Arthur Georgiadis is saying that General Johan Boysen refused the injured person medical attention, as suggested by Mr. Danigas in his evidence in chief.
What do you make of the sentence that says paramedics were not allowed onto the scene until the crime scene was properly secured? And then you read down, upon his arrival, Johan took control of the crime scene, giving instructions. The entire email, does it not suggest, when you read it as a whole, does it not suggest that the paramedics were not allowed?
I hold a different view, Madam Chair. It doesn't necessarily say so.
It does not say that paramedics were not allowed.
No, Madam Chair.
The sentence that says paramedics were not allowed onto the scene.
Until the crime scene was properly secure. That doesn't suggest, Madam Chair, with due respect, that General Johan Boysen refused that paramedics should be at the scene. But I'll leave it at that and proceed with other issues, Madam Chair.
Let me
May
find
provide.
out. I beg your pardon, Mr. Danikas. Please assist us with regard to Arthur's email, where he mentions the email. You see the email? He tells us that
Yes,
paramedics were not allowed onto the scene, blah, 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 blah. The question then arises, did Major General Boyson refused medical paramedics to come into the scene or into the scene or be called to the scene, because that's the point that council is seeking to clarify. He says the email does not say it is him, Major General Boysons, who disallowed the paramedics. Am I correct?
That's correct, Madam Chair.
What do you say to that?
So, Chair, Arthur wrote the first email, which you'll find out there's 3 paragraphs out of context to me. So, if you have to read them in reverse, once Johan, I'm reading the last paragraph. Once Johan has completed his tasks at the crime scene, we return to your apartment. So, there's Johan Boyson, which the middle paragraph says, upon his arrival, Johan took control of the crime scene, giving instructions to members of the unit that were involved in the shooting. At one stage, they were instructed to collect certain cartridges. So those were the tasks that a third person sees. It identifies Johan Boyson upon arrival, taking control of the scene,
Yes.
providing tasks and instructions.
Mr. Danikas, just answer the question briefly.
Sorry, apologies.
Yeah, just answer the question briefly. That the email of Arthur doesn't say so, that it is Major General Boysons who disallowed paramedics, correct?
My interpretation is that that's what he means.
I beg your pardon, I can't hear you.
It is my interpretation, reading that email, this is what Arthur means.
Yes.
He means that Johan Boyson controlled the scene and stopped the paramedics of entering the scene until they died.
You were present at the scene, am I correct?
Indeed I was.
Together with Arthur and others?
Yes, I was.
And you have made a statement to the effect that Major General Boysons disallowed paramedics, did you?
Yes, I have.
Advocate Mutlamunyani?
Thank you, Madam Chair. May I proceed?
In any event, will I be correct to say it is Arthur who can explain his email by not stating categorically who disallowed the paramedics? Am I correct? Am I correct, Mr. Danikas?
Is it to me? Yes, I agree with you. And again, there is a video that he collaborates further.
Proceed, Council.
Thank you, Madam Chair.
It appears that we are going beyond lunch break.
It's not lunch break, it's still past 12. But if we can take a 10 minutes break and come back. Is it 10 minutes? Just 10 minutes.
Actually not.
Maybe a convenience break would do, Madam Chair.
When my
To stretch
sisters-
our legs.
When my sisters are passing note to me, I think that it is lunch break. We will take 10 minutes to stretch our legs and reconvene at 10 to 1. Mr. Danikas, we are going to pause and take a break for 10 minutes until 10 to 1. Are you there?
Yes, I am.
You
Madam
continue
Chair.
to be under oath. We adjourn.
Yes, Madam Chair. Thank you.
Yes, thank you, Mr. Mutlamanyane. I was in haste for lunch. Mr. Danikas, are you there?
Yes, sorry, I was standing up.
I'm not sure whether you are like me. I was hasting for lunch. Are you?
No, I was standing up because you all enter in, so I thought it's protocol to stand up.
Yes, thank you, sir. You are still under oath. Mr. Mutlamanyane, you may proceed.
Thank you, Madam Chair. Let me deal with the Berea CAS 288-05-2008, Madam Chair. Mr. Danikas?
Yes, thank you. Like my sister on the right, I pinned my hand on it because you raised it earlier. And I was wondering when you were going to come to it. You remember you referred us to it?
I did, Madam Chair.
Yes, thank you.
Thank you. Mr. Danikas, are you on page 425, paragraph 79?
Yes, I'm there, Chair.
Very short paragraphs, only 3 paragraphs where you deal with Berea CAS 288/5/2008, where you went to the scene. Where you found this person already having fallen to the ground. You remember that?
Sir, yes. What do you mean I found him falling to the ground?
Nowhere in your testimony are you saying that General Boysen was present, not so?
General Boysen was never present on that scene, Chair.
So information that you received was from Inspector Mostert.
That's correct. I received a phone call from Inspector Mostert to attend the scene.
Were you invited to the scene?
Yes, by Inspector Mostert, a superior officer.
And he explained to you what had happened?
Not at this time. He just told me quickly, hey boss, come to the scene, and gave me the address. He explained to happen later on, or the next day when he came back to see me.
You are not the investigating. You are not the investigating officer.
No, I wasn't.
Let us go to Inspector Mostert's statement. It's contained, Madam Chair, in BR1, BR 0073, before we refer to this statement, just keep it in front of you. What is it that Mostert had told you?
You're referring, Chair, to the phone conversation when he invited me to the scene or afterwards?
When about what happened at the scene? What is it that he told you?
Mostert always used to come to my shop, and when he came to me, he explained to me what actually happened on that scene. Often the members will discuss scenes to me. So do you want me to elaborate on what he told me exactly?
Yes.
So he told me that they were going to look for a suspect, that they entered the scene, and he says he saw the lighty, and he says, oh man, I tried to help him. He apparently tried to escape by getting off, climbed off the window and tried to get to the one window next door. And he mentions to me that he leaned over. He says, hey, I tried to help the lighty, but then he fell and I shot him. He was like clinical. He was like, you know, that's it. That's all I knew. That's what he told me.
Did he not tell you that the deceased had a firearm with which he pointed at him?
No, nothing like that. It was a very short conversation. It was not like he was making fun of it. He thought it was funny. As he was falling to his death, he was going like this with his hand, bam, bam, bam.
You did not see that, not so.
No. Again, I said that this is what he told me.
Go to his statement.
Where do I find his statement, sir?
Can you flag it for us, please, Mr. Mutlokwane? Mr. Danikas, they will...
It is BR 0073 of the bundle 1 of 1. It's Katomena Dorcas Berea.
Is there a page, a PDF page I can type in?
No, Mr. Danikas, they will flight it for you. Don't worry. Can you zoom it, please? In the middle of, I'm not going to read the whole statement to you, Mr. Danikas. I will read the middle of 4th paragraph, although they are not numbered. I just counted them from the top. It's the 4th paragraph that starts with at 2240. Do you see it?
I can see that, sir.
Now, in the middle of that paragraph, Inspector Mostert says, as I entered, I was confronted by the suspect, Thabo. He was armed with a pistol, pointing it in my direction. I fired 3 shots in his direction. At this point, he ran towards the enclosed balcony with a window slightly opened. He dived through the window and fell to the ground. You see that?
I see that, sir.
Will you dispute that the deceased had a gun?
Chair, I was not there to see that, but knowing, having the experience, reading that sentence, I have my doubts.
You have what?
I have my own doubts.
Well, keep your doubts, Mr. Danikas. Thank you very much, Thank you very much, Mr. Danikas.
Could I just
I have no further
object?
questions.
No, I want to object. My learned friend can't escape with this recklessness. Oh, sorry.
Trying to talk to you.
I'm sorry, I was asked if I would
laughing,
dispute that.
But I'm not happy.
Mr. Danikas, please just wait a minute.
Yeah.
Please, before you answer, let the panel deal with the matter, the question, or the manner in which it is posed. My sister.
Thank you very much, Chair. Advocate Mhlamunyane, we are here to get to the bottom of the truth so that we can draw a comprehensive and intelligent report to the President. And I am sure, especially as the leader of the team, the chief evidence leader, you understand how to communicate. you ask a witness about a statement, he's not part of drafting that statement. He would or would not know the contents of the statement, but that's not my point of attention. I don't think it's necessary to deal with it now. What has now caught my attention is this response. A witness answers you, and he says, well, looking at the background that I have my doubts. And your response is, well, keep your doubts. Keep your doubts to yourself. Do you think it is proper for you to respond in that manner?
Yeah, upon hindsight, Madam Ramahaha, I apologize and I retract that statement, unequivocally apologize.
Yes, even when we at times get excited or depressed, can we just not let that get into our way as you do a very important function to assist us to get to the truth?
I agree.
Maybe also when you apologize to the panel, I think you are also indebted to the witness. It is proper that the witness understands and gets that apology. Can you do the right thing, please?
Yes, I will do that, not only to the witness, but to the public out there. I heartily apologize, unreservedly.
Thank you.
To the witness as well. I think he can hear. Mr. Danikas?
It's actually in the main to the witness, because
Yes.
it was a response to the answer of the
Can
witness.
you hear me,
Thank
Mr. Danikas?
Yes, sir, I can hear you.
Yeah, I apologize for the last remark that I made. Unreservedly.
I accept the apology. And if I may ask, English is my second language. I'm not a legal expert, so might also sometimes give an answer that might not be accepted to you.
Yeah, thank
you can
you.
just guide me. Thank you, sir.
Thank you for accepting. Madam Chair, I have no further questions.
Advocate Ngcukaitobi, re-examination.
Thank you, Madam Chair. Mr. Danikas, you said that you have enclosed a picture of Mr. Boysen standing next to a deceased African suspect. That picture, is this the one at 4A/20?
Can I have the PDF page number, please?
20 of the annexures. It's going to be flighted now.
Yes. Yes, I've seen it. I'm watching it also.
All right.
I personally
just give us a
took
second.
that photo.
Sorry, Mr. Danikas, just give us a second to put it up. Yes, that's the one. What's happening now? Okay. Yes. Can you tell us about this picture?
We were having lunch with Johan Boysen. A call came through. Again, the same motive. A call will come through, and Johan Boysen asked me to drive him to the scene. I remember I drove him. I used to have a Mercedes-Benz at the time, and one was crashed on the corner. We went to the scene, and Johan Boysen started processing the scene, and I was asked to take photos of that scene. I have taken actually quite a few photos of that particular scene. And I was asked by Johan Boysen to take that particular picture as a souvenir picture. When he stands there, you can see the body language, all proud, that's how I interpret it. Next to the two guys, which on the left, that's Mustard, and the other one is another person. Give me a second to give you the name. It will be I will come to the name. It is the same gentleman wearing the same clothes that it was part of the interrogation, torture interrogation. In fact, he's wearing the same clothes too. So And I was asked to take that photo, and I took that photo, gave a copy to Johan because she wanted for himself, and I kept copies also.
So,
Found
who is,
evidence.
out of those three gentlemen, who is Major General Boyson?
This is a person standing in front of the dead suspect with a tie and a smart, I think, black pants and smart shirt
Yes.
with the dog glasses.
And Inspector Mostert is the person kneeling with one leg.
Correct. And the person on the left, it will be, give me a second, for you exactly.
Well, the two gentlemen that were in the torture video, one was Inspector Pandey, and I can find the second name. The second one was Inspector Maharaj.
Maharaj and Pandey. That was Pandey.
So, all right, thank you. And those three, Mr. Boyson, Mr. Pandey, and Mr. Mostert, are they part of the Cato Manu unit?
That's correct.
And why did you take this picture? Because I understand Mr. Boyson instructed you to take the picture.
That's correct. Otherwise, I wouldn't have any authority to be on the scene and take the photo. Also, you will see that they've already marked the evidence, which means the forensics have already been there, because you will see a gun next to the deceased and a yellow circle around it, together with the cartridges marked. Now, I recall that I was also taking a photo in that scene. They asked me to point a place on the wall where some bullets were. So I was officially on duty when I arrived there with Johan Boyson, and the IPD, I think, or the forensics, asked me to assist them by pointing cartridges. It's a procedure we do where we have to use a finger to point out where the cartridges are, and we get photographed pointing at the evidence.
And when you arrived at this scene, was that firearm already there?
I cannot recall that, Chair. I honestly don't remember.
Yes. Now, what was put to you in cross-examination is that there are no similar pictures where Major General Boyson is taking pictures as a souvenir, as a sign of pride in having killed black suspects. Is that statement correct or not correct?
That is not correct. Here it is. There's a picture of him standing next to a dead body. I don't see the point of standing there and posing, because that is a pose. You can see the facial expression. He's proud of that. And they're all sitting there posing. I don't see the point of them sitting there once the forensics have been through the scene, once they have processed the scene, marked the scene, and those guys go out there and posing next to the dead body, next to an African dead body.
Thank you. Now, you were taken to AD 15. You remember that?
Would that be that Arthur's email?
Yes, the email from Mr. Georgiadis.
Yes, I remember that.
Can you go back to that email? It's at page 27 of the annexures.
I am the Chair.
Yes. Now, if you forget for a moment about whether General Boyson invited Mr. Georgiadis to witness the killing of the Mauros, and you just look at what he says, actually Major General Boyson did. The first one that he says that is crucial is in the third paragraph, where he says, at one stage, they were instructed to collect certain cartridges and to be removed from the scene. Can you see that?
I'm looking at it. Just give me a second, please.
Well, it's the sentence that starts with upon his arrival, Johan took control of the crime scene, giving instructions to members of the unit that were involved in the shootings.
Yes, I've seen it now.
So where we are now, General Boyson has taken control, is giving instructions, but one of the instructions that he gives is to collect cartridges to remove from the scene. Can you comment on that?
Yes, indeed. Boyson says, Ari, go around the scene, because remember now I've been around and know that I'm familiar with the scene, and pick up only the big, large cartridge, only the long one. And that is my understanding is the cartridge of the rifle, police issue rifle, which is the R5. So Arthur was next to me, and I started picking up the cartridges as I was instructed. And in fact, Arthur was so naive that he actually picked up some cartridges and I assaulted him and I took it off his hands. So I carried on taking the cartridges and hand them over to Mostert and Willifier in front of Johan Boysen.
But what is the point of General Boysen instructing the members, including yourself, to remove cartridges from the scene?
Based off what I've experienced and had and what I know, it's the fact that they use excessive force, they use automatic machine guns, based on the position of the first suspect who was dead, trapped in a car, multiple shots on him. I believe that they were executed, and I believe that they used maximum force to shoot to kill. But those men had no chance.
Yes, but why would you say take away the R5 bullets? What is it trying to achieve?
Tampering with evidence.
Yes, thank you.
So we don't. So the IPD who comes afterwards doesn't see any wrongdoing with the members of the force, of the police force.
Yes, thank you.
We need to take over evidence.
Yes, thank you. And then the next thing that is alleged in this, which again is not disputed in your cross-examination, is the following sentence, which says, once Johan had completed his tasks at the crime scene, we returned to your apartment where you showed us the videos you shot of the crime scene. Johan commented to you that you'd better get rid of it or you will get yourself into trouble. Now, this completely correlates with your own testimony and recollection of this incident. But I want to ask you a similar question. What would be the reason Mr. Boysen will say, get rid of the video that you took from the scene?
Sure. There are two issues here, and that's my understanding. One is that the way I took video and photos, it's incriminating, if I'm saying the right word, for both the Katomana members involved in that shooting and Johan Boysen himself being at the scene. Secondly, it was the manner, but the way those members were contacting themselves at the presence of a critically wounded suspect who died, and they're all waiting around for him to bleed and die and making fun of him. Thirdly, and this is something I find out many years later because I don't speak Afrikaans. Obviously, being Afrikaans, they heard the conversation among themselves, where they speak in Afrikaans, making comments. I believe one of the comments was from Adal was that step into his stomach. That was the translation. That dog doesn't want to die, or something like that. Step into his stomach to die faster. Things like that will explain to me later. So obviously he heard them, and he thought, oh, got a problem here. What is this Greek now he has captured? He never thought that that's going to be captured. And when we played in front of an audience, because there were others, to me that was like, hey, come see what I have. It's shocking. And I played because I had nothing to hide in front of witnesses. And he got up and he told me, get rid of it or else. And he walked away. He left.
But what is he trying to achieve by giving you that instruction?
Destroy evidence that they
Yes,
are
thank you.
implicating with the crime.
Yes, thank you. Then the last thing I want to ask you is around Berea. My understanding of what is being argued by the evidence leaders is that Major General Boysen had no involvement in Berea. Now, I understand that to be common cause, correct? You also accept that?
I'm sorry, I got distracted because somebody brought something into the room.
I'm sure they're
Apologies for that. Can you repeat the question?
I'm sure they're bringing you lunch. But
Yes, they did. Thank you. Thank you, the panel, for that.
yes.
You will enjoy that lunch soon hereafter. You'll enjoy that lunch, Mr. Davikus.
So what is being suggested? I'm talking about Berea, that specific scene in Berea where Mostert says to you, the light he tried to get out of the window, I tried to help him. It's unclear to me how he helps him by shooting him 3 times, but that's apparently the language at Keitoman. But what is being put to you by the evidence leaders is that Mr. Boysen was not involved in the actual shooting of the incident. What is that common cause? Let me ask an open question.
Sir, I could confuse with the occasion. Is it common cause? I'm
Well,
sorry.
do you admit that he was not involved in the actual interaction with the suspect?
When I went to the scene,
Yes.
Boysen was not there.
Yes,
You're not taking
yes,
it.
that's what I wanted. Now, what you testified about is not his involvement, but his knowledge and his failure to take action.
Absolutely.
Now, why do you say he had knowledge and he failed to take action?
Chair, as I have demonstrated with my statement and evidence, nothing passed through that involved, especially when involved, the killing of a suspect by the Katamani unit, but Johan Boysen did not have first knowledge of the incidents. It was shoot, phone call, shoot, phone call. And when Boysen called, he will come to the scene often to take care of the scene. If he was close by it was a very serious scene or something went wrong. So that is what I know. So now when the scene took place, because I went there and I felt embarrassed, it was 2008, it was at the end of my police career, and the members didn't allow me to come in. I got offended and I phoned Boysen and I told him what happened. And I said to him, look, this is what happened. This is also what Mosi told me. And I went there, there was a shooting. What's going on? He told me, don't worry about it, let it go.
Yes, but you narrated to him precisely what Mr. Mostert told you, which is what you've told this panel.
Yes, Chair, because it actually circulated among the members. And I'm not going to come across as desensitized, but they were making humorous gestures, which was circulated among the unit. So when we reacted with them, it was like, this is Mosi. And I'm trying to tell you now what came to my attention. It was, there's Mosi. Here, boss, let me help you. Bam, bam, bam. While the suspect is flying down. That was exactly what circulated. So I described that to Johan Boysen. I told him exactly what was going on, what I heard. I wasn't there, but what was circulated by Mosi in the unit. And he found it funny, actually.
Yes, so the idea that he had no knowledge of that incident, is it correct or false?
It is false. He had knowledge of the incident.
Yes. Thank you, Madam Chair. Thank you, Mr. Danikas. I have no further questions from the Chauke team, except to ask you whether you can help us to trace Arthur Georgiadis.
Indeed, I have provided the particulars of Arthur Georgiadis to your legal team. He is willing to testify and to provide sworn affidavit to the events.
Thank you.
Described.
Thank you, Madam Chair.
Sir, if I may, I'm permitted to add something which yesterday, while we had those Wi-Fi interruptions, my recollection of those got caught, and I could not explain what I want to explain in a question that was brought to me by the panel and the chair, if there's time.
You have just been cross-examined and re-examined. If you take us back, it means this process is going to have to follow. Perhaps you can recap and tell us in relation to which question before we consider whether you should deal with that aspect. Do you remember?
Yes, Madam Chair. May I proceed?
In relation to which aspect you'd like to answer? Or which question?
It was in relation to a question one of the madams addressed me yesterday, which had to do with that Berea case and my OB number records. The question was that there was no year reflected on that particular document that the panel has.
It's AD 17. Yeah, it was AD 17. Yes, AD 17.
I have it right in front of me. It's AD 17 at 4A-30. Because of the nature of the inquiry, I must place this on record. We will allow you, Mr. Danikas, to deal with that aspect, and we will afford Mr. Mutlamayani an opportunity to deal with this aspect also, if necessary, and council, if he wishes, can touch on that. Yes, you're referring to AD 17, the OB.
That is correct, Madam Chair. That is correct, Madam Chair.
It's
So,
at,
in response to that question,
is at 4A, if you can wait a bit. It is at 4A-30.
that's correct, Madam Chair.
Yes.
So, as I explained yesterday, I found my hard copy of that document, and attached to it, there is a transmission report, which has the actually transmission of the actually fax copy, which I was sending every month to the relevant department, police department. And when I went back into my electronic files, the reason why on the particular documents the year is not reflected is because the way I stored in my computer. So I had folders 2006, 2007, 2008, reflecting the year. And if you click and you open 2008, you'll find the months, January, February, March, May. And then I will print that relative page and send it to the to my police office where they kept my registry. And that explains the fact why the year is not reflected on top of the document. Thank you, Madam Chair.
Yes, I remember it's my sister who asked you about this document saying it does not show the year.
That's correct, Madam Chair.
Perhaps my sister would look at what you're saying now and develop that question if she wishes.
I think it was she was asking.
Yeah, thank you,
I
Chair.
can't remember.
The question came from me, and now from what he has told us about the transmission report, that has clarified it, that it was the year 2008. That is the only thing that I wanted to establish. As to in which year was it, the report states that it's May, but it was about, and the dates of the occurrences appear on the extreme left-hand side of the column.
Thank you, Mr. Danikas, for
Thank you,
elaborating
Madam Chair.
on that question. Council, do you want to make a follow-up on this point?
No, Madam Chair, thank you.
Advocate Mutlamayani, do you wish to ask anything
No,
on
Madam
this
Chair.
point?
No, Madam Chair.
Yes, thank you. Mr. Danikas,
Yes, Madam Chair.
we would like to take this opportunity as the inquiry, specifically as the panel, for you. Have you made time to come and testify? Do you hear me?
Yes, Madam Chair, thank you.
We would also like to thank you on behalf of the teams that are here, the evidence leaders and the Advocate Chauke's team.
Thank you.
In their respective roles that they are performing, more to us, for us as a panel. Thank you very much. You are excused.
Thank you, Madam Chair. Thank you, South Africa.
You can go. You can enjoy your lunch as we deal with housekeeping matters. We have few matters to address, but we wish you to enjoy your lunch. We hear it is right in front
Thank
of you
you.
there.
Thank you, Madam Chair. And
Yes,
if I may say that I appreciate the support the panel gave me. I appreciate the fact that the panel wanted to provide me with PTA support and pay for it, and I decided that I will decline that offer. I do not wish for a government expenditure to be provided. I will cover my own PTSD support, and that money rather go to a good cause in South Africa. Thank you, Madam Chair.
Thank you very much once again, and best wishes to your mother. We wish her a
Thank you.
speedy recovery.
Thank you, Madam Chair.
Thank you, sir. Advocate Ngcukaitobi.
Madam Chair, we don't have a witness ready now because our expectation was that this witness will go on until tomorrow. Our next witness's statement is sort of 50% ready, and that's going to be Mr. Spamandla Mhlongo, the current chairperson of the KwaMaphumulo Taxi Association. His statement is being prepared, but it is not ready. So I'm not able to commit that he can testify either immediately or tomorrow for that matter. So I would suggest, subject to the panel's concurrence, that we adjourn the proceedings until the end of the short adjournment, which is about a week, which I have no doubt everyone is looking forward to.
Yes, Council, my sister on the left reminds me, and I'm indebted to her, that the parties had agreed about the time frames for filing of pleadings, if I may refer to those documents as pleadings, no? In the Advocate Batoi's application. Have you drafted any agreement? Have you reached any consensus?
Madam Chair, there is progress, even if it's tentative, because I discussed this morning with Advocate Mtsweni, that he will draft a statement of common cause facts in relation to the Mdluli matter and furnish us with that. And we can comment on whether there are facts on which we disagree, and then the witnesses to be called would be limited to those facts on which there is disagreement. In relation to the Ketumano,
No, I'm talking about something different. Sorry. My apology, I didn't make it clearer.
oh, yes,
Council.
sorry.
It's in relation to the pending
Oh, yes, yes,
application
yes.
by Advocate Batoi,
Yes, yes, yes.
to which you have now responded.
Yes.
Advocate Batoi has not filed a replying affidavit, if my recollection is correct. And we spoke yesterday, I think, about the time frames as to when documents will be filed of record and when submissions will be filed.
No, but I think my attorney.
Yes,
Would be better
the
placed.
attorneys were speaking, counsel. I was actually addressing it to Mr. Nkabinde. And you can bring the roving mic to Advocate Batoi's attorneys from Molebatsi et al. Attorneys, so that you can tell us whether you agree with Mr. Nkabinde about those issues. Have you reached an agreement, Mr. Nkabinde?
Chair, we have been so much absorbed with the evidence aspects, we haven't had the opportunity to speak with our counterparts. The standing arrangement, though, is that they would deliver their replying affidavit by Monday the 16th. The only issue is there's some tentativeness to it, and that tentativeness is they suggest that they might well do it earlier, but they haven't indicated whether or not earlier will eventuate, and if earlier, when that will be, and from that would follow an agreement between the parties regarding the filing of the submission. So if the panel allows us with this early adjournment, we should be able to finalize those details and report to the panel before we leave the building. Thank you, Chair.
Madam,
Thank you, Judge.
just remind me your name.
Lesego Mabena.
Ms. Mabena.
Yes, so Mr. Mkabella's recollection of events is correct. We have in fact prepared a letter proposing specific dates as directed by the panel yesterday, and we will get that to Mr. Nkabinde this afternoon.
And remember, when we spoke in chambers, we were displaced by the fact that you are giving tentative dates. You should just indicate that you'll file on X date, not tentatively, so that then you can both consider the appropriate times to file submissions. You can even agree to file your submissions on the same day, like we have done with regard to the other interlocutory applications. But we need your agreement, otherwise we will place you on terms if you don't agree.
That's an order, Judge. We'll revert to Mr. Nkabinde with those proposed dates and inform the panel accordingly.
Mr. Nkabinde, will it be possible to sit with your sister and draft that agreement and cause it to be filed of record today or tomorrow, so that we know exactly when and what to expect?
We will endeavor to do so before we leave the building, Chair. Thank you.
And to the extent possible, please use the recess break to file the written submissions.
I was assured by our leader yesterday that if it has to be done in that time, it shall be done. Thank you, Chair.
We will await your agreement, which if you file this afternoon, we will consider how to deal with it. We may endorse it, and we may not endorse it. So please file the document of record this afternoon so that we can guide you. As regards what you have brought to our attention, Mr. Advocate Ngcukaitobi, it does not appear to us that we have control over the situation regarding the availability of the next witness. We have only tomorrow, and it may not make any sense to postpone these proceedings to tomorrow when you have given an indication that you are still consulting with the next witness. But let me give the opportunity to Mr. Mutlamuyani for what it is worth to say your bit.
About witnesses.
About what counsel, what Advocate Ngcukaitobi has just said regarding the position, their position.
Yeah.
Anything else that you'd like to say, or anything else?
No, not exactly. If it is beyond anyone's control, the matter cannot be postponed to tomorrow.
Yes.
They are still busy with their statement, the statement of the witness, and it's beyond our control, and anyone's control really.
Might I also emphasize that this short break will enable you as evidence leaders also to finalize your consultations and your witnesses, make the statements ready or available to us, and also to Advocate Chauke's team. Use this recess. You know, recess is not a holiday time. Even when we are in court, a recess is never a holiday time. We simply shift tables and work elsewhere. So to all of you, please use this period to read, consult, prepare, and exchange statements. File them of record timelessly so that we can read and not read on the day of the hearing. We hope that by end of April, and I must mention it right now, we hope that by end of April, all witnesses would have been brought before us, so that beginning of May, you should work on your submissions to enable us to prepare the report. We will repeat it again when we reconvene so that you do not say you are taken by surprise. In the event the inquiry is going to be postponed or is postponed to Monday, 23rd of May, 2006.
I think March, Madam Chair.
20. I must recall this order. In the event, the inquiry is postponed to the Monday, the 23rd of March 2026. Thank you for reminding me of the dates. May is my birth date, so maybe I'm rushing for that. Thank you very much to all of you. I wish you a restful break, and we hope that when we reconvene, all of you would have rested. We adjourn.